Hello, hello, everyone. So, I am going to discuss the competence to exercise the right to remain silent. To give it a little history and how the right to remain silent kind of came to fruition, we'll start with talking about interrogations and how extremely stressful they are. Especially back in the day, old police techniques didn't really have any regulations or rules as to how they can conduct interrogations. So they would also often result to physical torture, abuse, psychological, emotional torture to gain confessions. This could include anything from beatings to giving them no breaks to questioning them for hours and days on end, not allowing them to contact their friends or family, not giving them food or water, anything like that in order to elicit a confession from them. And oftentimes they would falsely confess just to get all of this, to stop. And Casson and Wrightsman kind of outlined that, as well as two other reasons to falsely confess. So, along with coercion due to the, physical, emotional abuse, people can confess for popularity and personal gain. So they want to remain in the spotlight. They want people to know that they did it to gain some sort of satisfaction, um, and infamy out of that. Or they can confess due to the internal belief that they are, in fact, guilty, which is crazy. Essentially, police are so good at being tricky and manipulative that they make a story and a narrative to get the suspect to truly believe that they actually committed the crime. Um, where this kind of all boiled over was in Brown v. Mississippi Supreme Court case in 1936, where a man was brutally assaulted, tortured, hung, beaten, uh, and in order to gain a confession. And essentially, he did end up confessing and wrote down his confession, an admission of guilt. However, the court ruled that the confession was inadmissible at trial due to the fact that it was obtained through physical coercion by police. And this kind of set the basis and standard moving forward to ensure that all defendants had the right to the due process of law, to ensure that they're protected during these interrogations, first and foremost. And, at the end of the day, confessions should be voluntary, but how do we help to ensure that they actually are? Miranda rights come into play here. So a few years after Brown v. Mississippi, Miranda v. Arizona 1966 ruled that upon arrest, the arresting officers needed to provide the suspects with their Miranda warning, and they had to say it verbatim at the time of arrest to ensure that the suspect was protected underneath their Fifth Amendment right against self-incrimination. So their right to remain silent. Anything you say can and will be used against you in a court of law, and then the other ones are right there on the picture. So one of two things can happen after you are given your Miranda warning. One, you can listen. You can remain silent. You don't have to talk. You don't have to say anything, and so you have an attorney present and all that stuff. Second, you can decide that you want to talk, you want to say something, you want to confess, and in that case, you would waive your Miranda rights. However, to do so, you have to be competent enough to do that. So the standard for that is kind of you must knowingly, intelligently, and voluntarily waive those rights, and we'll go over that in a second. An example of this in a real case was Colorado v. Conley in 1986. Essentially, a Denver police officer had confessed to a previous murder, and he flew all the way to the detectives, confessed. Nothing was out of the ordinary. He didn't seem um, weird or anything like that. However, people found that he had previous psychological issues and mental disabilities. So it was brought into question on whether or not that confession was admissible due to the fact that, he was incompetent or suspected to be incompetent to waive his Miranda warning. Um, However, the court upheld that his confession was given voluntarily There was no police coercion involved. The police actually gave him many Miranda warnings at multiple points throughout the process. No abuse, threats, bribes, or nothing was found, and no mental impairment was found either. Um, that would affect his ability to give it voluntarily or know what the Miranda warnings are. So he was found competent to waive those rights and confess. However, what happens when you're not found competent? In order to answer that question, we have to know what competency is. So it rose from English common law and focused on the 14th Amendment to the Constitution, which is your right to due process or equal protection under the law. Right now, it's pretty much guided by the Dusky standard in the Dusky v. United States Supreme Court case in 1960, which laid out the federal standard for competency. States pretty much stick to this standard. There may be some variations here and there, but it's pretty, uniform across the board. And the definition is right here if you would like to read it. However, three things that I took away from this definition that's very core, basic core, are these three questions here. So first, can the defendant communicate and work with their counsel? Do they know the lawyer relationship? Do they know what they do? Does the defendant know the trial process slash court proceedings? Do they know what a judge and jury are? Does the defendant understand the charges against him? Does he know what he's being accused of, who he's being accused by, what the repercussions of those accusations are if he's found guilty, those kinds of things. So when you're determining competency to waive a Miranda right to remain silent, there's kind of two groups of things, three things in particular that you have to look for. So the first thing is, was the confession given voluntarily? You want to take a deep look into the interrogation process to see if at any point there was any police coercion or manipulation. So did the police threaten, bribe, any leading questions, stuff like that to get a confession? And then you also have to determine the defendant's level of suggestibility. How likely are they to just go along with something and say yes? So this could be anything from how they view authority figures. So are they just saying yes and confessing because they're police officers, because they respect that person's in a position of power? Were they under the influence when they wanted to waive their rights and confess? We're more likely to do things we wouldn't normally do if we're under the influence of drugs or alcohol. So that makes us highly suggestible. Next, any intellectual disabilities. Are we able to understand that we're confessing to something? Do we understand what we're being told and what we're agreeing to? Anything like that. And different suggestibility scales can be used to gauge the level of suggestibility for these suspects, accompanied with any sign of police coercion to determine if a confession is in fact voluntary. Additionally, you have to know whether or not the defendant knowingly and intelligently waived their right to confess. So you need to be able to not only understand but you have to comprehend the Miranda rights as well. So like I said, you can waive your Miranda rights at any time. So if I got arrested today and I understand my Miranda rights, if I want to confess in 3 weeks, do I remember what those rights are? Do I remember what they mean? So that can be tricky. Unfortunately, about 23% of adults did not understand at least one Miranda right in a study done in the textbook. Juveniles and intellectually impaired individuals are even worse off, and they have further misunderstandings. So if you don't understand one part of the Miranda warning, it's very difficult to assume that you understand the rest of them, as all of the rules are just as equally as important. If you're found incompetent to waive your rights, unfortunately, it's probably too late. You've already confessed. And again, false confessions come into play here. Although other evidence is often required, these, confessions hold a fair amount of weight in court, and they're, hard to overturn. Once you've admitted your guilt and, signed it, written it down, it's hard to take that back. So hard, in fact, that 400 out of approximately 3,400 of those who have been exonerated since 1989 involved false confessions. So they stayed in prison for X amount of years um, due to false confessions or um, with the assistance of a false confession um, without being exonerated. A good example of this whole, discussion is Joseph Arity, who was charged with rape and murder in 1936. I bring this up because it happened around the time Brown v. Mississippi did, and it's just a good case to outline what happened before Miranda came into play. So he was caught wandering in a neighborhood where this 15-year-old girl was raped and murdered, and they caught him because he matched the description. He was severely intellectually disabled and he had a prior history of suggestibility. His friends at one point had told him to tell police that he stole cigarettes when it was in fact his friends who did it. So he would pretty much go along with anything. His friends and family said he was extremely gullible and would pretty much say anything if he was told to. And he had an IQ of only 46. So when police questioned him, they gave him leading questions. They would say, why did you hurt that girl? If you like girls, why do you hurt them? Just stuff like that. And he kind of, obviously didn't understand um, tricky police manipulating uh, techniques. So he ended up confessing and incriminating himself. He was convicted of the crime and sentenced to death. He died, he was executed in 1939, and um, for his last meal, he wanted ice cream, and he even asked if he could save his ice cream for later. But he was going to be executed later that day. So he didn't even understand the death penalty and what that meant. So he was incompetent to do that. So he was incompetent pretty much throughout the whole entire process, but it wasn't, back then it wasn't a big thing to look for. So unfortunately, he was one of those that fell through the cracks, but now, Miranda rights are here, and hopefully, they're gonna help. And here's a short clip that you can go ahead and watch for Joseph Arity. Like I was saying, Miranda rights hopefully can start to help people, but you also need some checks and balances in order to test the people who want to waive their Miranda rights to see if they are competent to do so. And I have outlined here some of the tools and instruments that were mentioned in the book. Essentially, Gristle's instruments range anywhere from, do you know the Miranda rights? Are you able to recognize them after the fact? Are you able to pick out key vocabulary and key terms from the Miranda rights? And do you know how those rights function in the interrogation process? Another version of this test was given where there was more test questions to help cover any cracks, and the language was really simplified, probably to cater more towards juveniles and intellectually impaired individuals who might not be at the same reading level, because the Miranda warnings, it's universal. The phrasing's the same if you were 18 as if you were 80. So some people might not understand depending on different, things that are going on. And, ideally, this is supposed to help with preventing incompetent people to waive their Miranda rights and confess, especially if that leads them into a false confession. So hopefully these are being used as they're supposed to be used, or tools like these at least, in order to help catch those people who really don't understand the rights that they're giving up and the repercussions of doing so. Here's a question that you can think about. The Colorado v. Conley case was a little tricky because he did have a past history of psychological impairment, and he was sort of clouded by delusion that he had to confess, like something was making him confess. So, do you believe that the standards to remain silent are sufficient enough to determine someone's competency level? Why or why not? And then you can use this case as an example to see if the standards, if he met the standards or not.